I'm just going to see if I can share my screen here. Hopefully everybody can see the slides.
Yes, that's perfect.
So what I want to talk to you today about for a little while is returning to work after the COVID pandemic. And I feel like a little bit of a fraud starting with that introduction because we're not after the COVID pandemic, clearly. And we may not be in a post-COVID world for years to come. But here's hoping. The other reason why I suppose there's a degree of uncertainty is that when one analyzes the idea of returning to work after COVID from a legal perspective, there are some problems presented immediately by the degree of uncertainty as to what's going to happen in the future and the age of our applicable laws. So today, we're going to be talking about what I class as soft law. Okay. Now, what do or how do I explain the difference between hard law and soft law? Hard law is law that has been enacted by the Oireachtas, so it's in the form of statute or statutory instruments. It's there for everybody to read. You can download it from the internet. And it's also in the form of decisions of the courts, the Workplace Relations Commission, the Labour Court, etc. And again, an immense amount of that is available to view and read on the internet. But right now, we're in territory where we're having to discuss and consider and look at soft law. Now, what do I mean by soft law then? Well, it's not legislation. It's not decisions made by judges. It's guidelines that have been produced by government or government agencies. It's codes of practice. It's policies. And very often, I think we'll find this morning, it is simply an indication of possible future government action or policy, very often that's been communicated by the current Taoiseach through tweets or press releases. And so today, I'm going to talk to you a little bit about the Work Safely Protocol, which is a document that's been produced by the Health and Safety Authority, the Department of Enterprise, Trade and Employment, the HSE, and the Department of Health, but a document that doesn't have strict force of law. So it's meant to be indicative of best practice and what the government expects of employers and employees as they return to work after COVID, but it is not, strictly speaking, legally binding in and of itself. The second issue that I want to touch on seems to be a bit of a topical one, and driven by the conversation, I think, in large part in the UK, where people are discussing this idea of COVID testing and vaccination and whether employers can require employees to undergo COVID testing and vaccination, whether they can require employees to divulge information about whether or not they've been vaccinated, etc. So on that one, at least, I hope to give you a very clear answer very shortly. The third issue that I want to touch on is the idea of employees resisting returning to work. And I think many of us are worried about that, particularly smaller employers. And those who've already returned to work or asked employees to return to their workplaces have almost always encountered some problems on that front, where there's always one or more employees who are happy to be sitting at home in receipt of COVID PUP payments or working from home and able to keep an eye on the kids at the same time, etc. So there's certainly a percentage of the working population who are resisting returning to the workplace, sometimes legitimately, and sometimes perhaps not. The fourth issue that I want to touch on is the right to request remote working that's been receiving a lot of publicity recently. The Taoiseach made announcements in that regard in January, and there have been a number of publicity splurges on the issue which have led some people to believe that there already is a legal right to request remote working. I think we'll find very shortly that that's not necessarily, strictly speaking, the case. And the fifth and final issue that I want to touch on today is the so-called right to disconnect that has allegedly been introduced recently. And again, I have to cast a little bit of doubt over whether or not it's an actual legal right, but I'll explain why very shortly. So it's been an extremely difficult time since around March of last year for many people. Some people have suffered horrendous losses, dreadful illness. Workers in the healthcare sector have been under extraordinary pressure, and many of us have suffered significant economic and health-related impacts as a result of the COVID pandemic. But that's not the whole story. From an economic perspective, I was interested to hear Ivan Yates speaking in an interview a couple of months back, where he said that really people are divided into three camps by COVID from an economic perspective. He said for about a third of the population, a third of the working population, it's had no economic impact at all. And he suggested, this is not my assertion, it's his idea, but it makes some sense to me. He suggested that about 1/3 work in the public sector, and that's why it's not impacted on them from a financial perspective. Now, I don't want to have lots of public servants up in arms as a result of my having said that, but that's the suggestion that was made. He said about 1/3 of the economy has boomed or prospered as a result of COVID, which is a prospect that I wouldn't have foreseen right at the beginning. And perhaps that's why Mr. Yates is better positioned to comment on economic issues than I am. But there are certainly, and I can see this on a daily basis, there are certainly clients of mine and clients of other solicitors who have made a lot of money out of the pandemic, not through acting improperly, but because they happen to be supplying personal protective equipment or manufacturing vaccines or otherwise assisting in a significant way in the battle against COVID. And then there's 1/3 of the economy, Mr. Yates says, has been devastated. And I think we've all seen its impact on the hospitality industry. I'm looking out the window of my office here at a hotel in Enniscorthy that has been closed for much of the last year. Normally, there would be a lot of activity out there with guests coming and going to check in, to depart, people making use of the restaurants and pubs that are within that hotel, and the doors have been shuttered for most of the last year. So that clearly is going to have a devastating impact on people working in that sector. Well, right now, the prospect is being we're looking at returning to work. Although I do recall involving myself in a webinar last year with County Wexford Chamber, where we were talking about reopening the economy in the autumn, and I think we were all disappointed to a large degree. Certainly the doctors that I'm speaking to, most of them are suggesting, and I don't want to get people to shut down the webinar from on their screens right now, but a lot of those doctors are suggesting we're going to hit a further wave because of the Delta variant and subsequent variants, and that we'll be looking at another lockdown in the autumn. Hopefully that proves to be the case. Hopefully we can afford to be more optimistic today and talk about reopening in more detail. So in terms of those issues that I wanted to discuss, the first one is the work safely protocol. Now, there's been a number of iterations of this. The work safely protocol was published initially in November of 2020. In fact, I've got the wrong number on screen there because there was a second iteration in December of 2020, and now we've got the third iteration from May 2021. I'm hoping to put a link on the Jacob and Twomey Solicitors website just after this talk, so it should be up by lunchtime, where you can download all of the documents that I'm going to refer to this morning. I've prepared a pack of them for you if you want to be able to refer to them. Sadly, it's about 150 pages in total, but it's a mine of information in terms of returning to work if you're having to plan for that over the coming months. The first of those documents, and there's a link on my next slide, so you'll be able to get those slides from the Jacob and Twomey Solicitors website as well, and hopefully Emma will be able to provide them via County Wexford Chamber as well if you'd rather source them there. But that document, that work safely protocol, is a very substantial document that's been produced by the 4 agencies I mentioned earlier, the HSA, the HSE, the Department of Health, and the Department of Enterprise, Trade and Employment. Over the last several months, it runs to almost 80 pages of advice and guidance for employers and employees who are returning to the workplace. I think it's interesting that it was produced by those 4 agencies, all of which are public sector or government. And I suspect that a lot of the input into the document has come from public servants who normally work in pretty sizable offices in Dublin. Because if one was to follow all of the guidance that's provided in the Work Safely Protocol, and again here, I'm hesitant to speak my mind in circumstances where this is being recorded and will end up on YouTube, but if one was to follow all of the guidance in that document to the letter and follow it well, then I suspect one would have to have an awful lot of time and an awful lot of resources in terms of people to implement all of the measures. It's a protocol that I think will be relatively easily followed by very substantial multinational organizations who have 5, 6, 7, 800 employees and who are based up around Dublin or the hinterland of our capital city. I struggle to see how small businesses in County Wexford or in other parts of the country are going to implement all of the recommendations that are contained in the Work Safely Protocol. Well, why? What does it say? Well, it says an awful lot, okay? So it covers, and I'm just looking at a copy of it here, it covers a variety of different issues, like the requirement that it suggests should be imposed on employers to provide information to employees about COVID-19, about how it spreads, etc., etc. To some extent, I would have thought that that's the responsibility of the state, of the HSE, of the HSA, etc. But it's not the most tricky one for employers to deal with. You just need to make sure that you're up to date with the latest public health advice and that you're communicating it to your employees. Second thing that it covers is the requirement that employers have a COVID-19 response plan. Now, that's fine if you have an environmental health and safety officer who has appropriate qualifications working for you, or you can afford to go out and hire a consultant who works in that area to help develop it. But I'm wondering how the 3 or 4 person accountancy practice or estate agent or small construction contractor will manage to find the time and resources to put all of that together. Nonetheless, we're expected to have a COVID-19 response plan, keep it up to date, monitor it, amend it as the public health advice changes, communicate those changes to our employees, and so on. We're asked to implement and maintain policies and procedures for the prompt identification and isolation of workers who may have symptoms of COVID-19. And it goes into quite a bit of detail there and says that in each workplace, there is to be an isolation area and an isolation route, so that if one suspects that an employee has contracted COVID-19 and is suffering from it, they're to be guided down the isolation route to the isolation area in your very substantial offices, obviously, if you're going to be able to provide an isolation room or area and an isolation route. You arrange for transport home. They're not to go on public transport. And but one of your other employees or you yourself are meant to expose yourself to potential COVID infection by bringing them home. I'm going to have to roll back a little bit on the cynicism because I think what I'm saying might be dripping with it. So apologies if it is. It talks about hand hygiene in the workplace. It talks about respiratory hygiene in the workplace and reminds us of all of the standard advice with which we're all very familiar at this stage. It talks about physical distancing, keeping 2 meters apart, and alternatives if that's not always possible. Working in pods, so a little bit like we're used to seeing the kids in school. It talks about a variety of pre-return measures that we're meant to put in place. So we're all supposed to generate questionnaires that we issue to our employees before they return to work. We're supposed to keep a log of contacts, people they come into contact with at work, including times, dates, phone numbers, et cetera, and we'll come back to that point a little later in the context of GDPR and data privacy. It gives us some guidance in relation to at-risk workers, and critically, it tells us that where possible, we're all still supposed to work from home. Now, that's an interesting one, okay? Because we're talking about opening up the economy. We're talking about returning to work, but the official advice in the return to work or work safely protocol is work from home where possible. So if you open up, and you didn't have to open up in order to do work, if you get people back to the office, then arguably you're acting in contravention of the return to work protocol or the work safely protocol. And the lawyer in me says immediately you're putting yourself at risk of claims if people contract COVID in the workplace. Now, when we spoke last year, or when I spoke with some of you last year on the equivalent webinar in the summer of 2020, I took a risk and I predicted that there would be a significant number of personal injuries cases arising from the whole COVID pandemic, where employees claimed that they contracted COVID in work because their employers were negligent in failing to put a proper series of measures in place to limit the risk. And in all honesty, I haven't seen that materialize yet, but I'm not giving up on it. I do think that risk is still there. I think it will take time for the COVID-related claims to materialize. In the employment law world, for example, we're seeing solicitors who practice in the area of employment law, we're seeing issues arising in workplaces. We're seeing employees refusing to return. We're seeing employees being asked to provide vaccination data, objecting to doing so. We're seeing employees resigning because they claim that their employers are not putting appropriate measures in place to protect them. We're seeing employees resigning because they're being required to return to work and they say they should still be working remotely in accordance with government advice. So we're seeing these issues arise on a day-to-day basis. We're not seeing the decisions flooding through that clarify the law on those issues. And that's because the Workplace Relations Commission has effectively been shut down for quite a number of months in 2020. At one point, I understand staff were reassigned to assist the HSE with contact tracing. Whether that's correct or not, I'm not 100% certain, but I was told that that was what was happening. So there were no cases being heard for several months in 2020, and that meant there was a backlog of cases building up. Then we came into 2021, and after the delayed introduction of remote hearings that are conducted virtually, the Workplace Relations Commission was hit with a Supreme Court decision that indicated that the procedures that they were following, the procedures set out in the Workplace Relations Act 2015, were constitutionally deficient in certain respects. And so emergency legislation is being rushed through the Houses of the Oireachtas at the moment in order to address that concern, but a large number of cases have been postponed as a result of that constitutional decision. So I think it's going to be late this year by the time we're going to see any significant number of decisions emanating from the Workplace Relations Commission in respect of all of these COVID-related issues that have arisen in the workplace. And then we could see a flood. And in the same way, I think after things have calmed down, we're quite likely to see personal injuries litigation where people are saying, I have suffered the following effects from a health perspective because of COVID. I had long COVID. It has resulted in me suffering damage to this organ or that organ. And that's my employer's responsibility because I contracted COVID at work. There was an outbreak in work. I think we're going to see those kinds of personal injuries cases emerging. But right now, very hard for a consultant to write a report saying, this is what has happened. This is what the future is going to look like for this plaintiff. And so I think there might be a delay before we see those cases coming through. In any event, with apologies, I've allowed myself to become sidetracked into prospective litigation rather than dealing with the some of the fine detail of the work safely protocol that I had hoped to address. It also covers issues like the type of cleaning that should be going on in workplaces, the type of PPE that should be furnished to employees and when, how to deal with customer-facing roles, minimizing human contact in those roles. It talks about circumstances in which vaccination should be offered to employees, and it seems that the general position right now is that if people are expected to work with COVID, which is a biological hazard, then they should be offered vaccination. And that's going to arise where they're working in healthcare environments, for example. But generally speaking, there's no general obligation at present to offer vaccination to employees. I think the safest thing to do in relation to the work safely protocol is to ensure that you read it at a minimum before returning to work. If you've already returned to work and you haven't read it, then you need to start immediately on dealing with the recommendations that are contained in the work safely protocol. I think those who fail to follow the work safely protocol are taking a risk from a legal perspective and from a health perspective, arguably, but certainly from a legal perspective. I'm not a doctor, so I'm not qualified to advise on the medical risk, but from a legal perspective, if you fail to follow it, you could find that it's being quoted against you in court down the line. And of course, everybody is going to be an expert after the event. So leaving the work safely protocol behind for the moment, I just want to talk to you a little bit about COVID testing, vaccination, consent, and data privacy. There have been lots of debates in the media, I think particularly driven by the UK media in light of some of the comments that have been attributed to leading politicians in the UK about requiring employees to be vaccinated before they return to work, or requiring them to confirm whether or not they've been vaccinated before they return to work, or requiring them to undergo COVID tests before they return to work. And people have been asking, can you do that? Is it lawful? Are there data protection concerns? What's the position? Well, very usefully, we've now got some guidance from the Data Protection Commission on all of these issues. It's short, it's sweet, it's to the point. It's problematic as far as some employers will be concerned, but essentially it goes back to first principles in relation to data protection. So the two pieces of guidance that I want to talk about very briefly are firstly, and perhaps most importantly, the very recently issued guidance from June of this year on processing COVID-19 vaccination data in the context of employment. And then secondly, I'd like to talk for just a moment about the guidance that was issued in September of last year by the Data Protection Commission on processing customer data for COVID-19 contact tracing purposes. So a little bit of introduction here, a little bit of background. As you may or may not know, the General Data Protection Regulation came into effect across the EU in 2018. And it's a big legal instrument that is set out in what I call Eurospeak. Okay, so very vague terms, sometimes unusual language employed, difficult to interpret and difficult to apply. And that's because it was expected, it is expected at EU level that national governments will implement local measures or national laws on the issues as well. So we've got this big general regulation that's difficult to understand and has been giving rise to all sorts of difficulties for employers, companies generally, and lawyers over the last 3 years. And it's backed up by the Data Protection Acts 1988 to 2018 in Ireland. And GDPR effectively is designed to minimize the volume of personal data that companies collect and restrict what they do with that data once they have it, and enable data subjects, individuals like you and me, to find out who has what data on me and why are they using it, for what purposes, etc., and to ensure that the data is deleted once the purpose for which it was collected has expired. Now, I always think it's easiest to understand GDPR in the context of social media and the social media giants. So if we take Facebook, for example, if I have a Facebook page, I am voluntarily dumping lots of personal data onto that Facebook page. And so Facebook acquires it. And the EU was concerned about social media giants using data that's collected for one purpose in other contexts, like selling that data to marketing companies. And I'm not suggesting that Facebook does that, although there are very clear allegations out there about certain companies selling data. But the instrument itself, GDPR, is designed to deal with that big picture issue. But it applies to everybody who collects data on a commercial basis. And so it applies to very small local businesses in County Wexford and elsewhere as well. So that if we're asking employees to tell us whether or not they've been vaccinated, when they got vaccinated, possibly what vaccine they got, we're asking them to give us personal data about themselves. And it's a special category. It's sensitive personal data because it's medical in nature. And normally, we don't want to obtain too much medical data in relation to our employees. It's none of my business whether or not one of my employees is taking a daily anti-cholesterol tablet, generally speaking. I don't need to know that. And so I shouldn't know it, and I shouldn't retain data of that type normally. But at the moment, it's being suggested that employers should be asking employees to tell them if and when they've been vaccinated. And so what does the Data Protection Commission have to say about that? Well, they say that in general terms, it's inappropriate and improper for employers to be collecting and processing vaccination data in relation to employees. There are limited circumstances where it might be necessary, but they say there is no public health advice out there at present to the effect that employers should be collecting and processing that data. They say that it is unnecessary. They say that it is the collection of an excessive amount of data about employees, and that there is no clear legal basis for doing so. So there's your answer. The Data Protection Commission is effectively saying that it is generally illegal to look to collect vaccination data about your employees under GDPR and the Data Protection Acts. They say it's possible it's likely to be lawful in some limited circumstances. And what examples do they give of that? Well, they give the example of the medical council having advised that medical practitioners should be vaccinated against common communicable diseases. So they're suggesting that it would be lawful for a hospital, for example, employing doctors to require that those doctors are vaccinated and therefore retain data in relation to whether or not those doctors have been vaccinated. But generally speaking, the Data Protection Commission says we should be responsive to the principle set out in GDPR of data minimization. So we keep the minimum possible level of personal data about employees. And they say that in the context of COVID, there are a range of other anti-COVID-19 measures that should be employed first before we consider collecting data about vaccination. The other comment that they make, which I think is interesting, is they say that vaccination is voluntary, which of course it is. They say that the long-term effects of vaccination are not yet clear, which is a slightly disturbing comment to read from a state body in circumstances where I had my second jab recently. They say that there is an imbalance in the relationship between employers and employees, in that I think what they're suggesting is that employers have a greater degree of power than employees, and that any consent that might be given by employees to collect and retain vaccination data isn't freely given. So the bottom line in terms of requiring your employees to tell you whether or not they've been vaccinated is that for the overwhelming majority of employers in County Wexford and elsewhere around the country, it's regarded as being illegal at present. Now that may change. We could talk again in a month and there might have been a High Court decision on the issue, or the Data Protection Commission might have reconsidered its view in light of decisions published in other countries. But right now, don't go there, is my advice to you. Second interesting publication from the Data Protection Commission was in September 2020, and that was in the context of contact tracing. And you might recall that when certain types of employment reopened, it was advised that, and this is advised, that certain data be collected from customers. So we've all been in a situation where we've gone to, I don't know, a gym or a pub, or maybe not a pub, they weren't open very long, a cafe, a restaurant, whatever, at different points in time when they were open, and we've been asked for our contact data. And just from my own experience wandering around County Wexford, there's great efforts being made by employers and businesses to comply with that contact tracing requirement and to facilitate public health authorities, but it's being done in many workplaces in a manner that is completely inconsistent with GDPR and the Data Protection Acts. So today, I will certainly have at least 2 occasions where I have to visit premises and I will be asked to write down my name, my phone number, time and date of visit, and possibly some other data. And it'll be done in a completely unlawful way because there'll be a sign-in sheet at the door. I've had a couple of examples of this. You get to the door, you write down your name, your phone number, and your time in. And then somebody behind you comes along and they can read your name and your phone number. I'm not too worried about it. I'll be able to deal with crank calls. But I would worry about my 18-year-old daughter writing down her name and number before some creep comes up behind her and jots it down or takes a photograph of it on his mobile phone. Please God, she'll never see this video on YouTube and no one will ever bring it to her attention because she already thinks that I monitor her far too closely. So be careful when you're doing the contact tracing data collection. Number one, bear in mind that the Data Protection Commission is saying we need to minimize the volume of data that we collect, okay? So they say, normally, there's no requirement to collect anything more than an individual's name, telephone number, and the time and date of their visit to your premises. No more than that. Interestingly, the return to work protocol that I discussed earlier suggests that that is the absolute minimum data that should be collected. So 2 different documents from 2 different state agencies, very close to contradicting each other. Data Protection Commission said that you have to be absolutely transparent about the reason for collecting the data. So your staff need to be able to explain to people why you're asking them for their name and phone number, okay? So your staff need to understand what's happening and need to be able to explain it. And that sheet where you get people to fill in their name and number, well, I think the sheet is a bad idea because you can immediately see the previous visitor's name and number. But if you give each individual a slip to fill out, it should state why you're collecting the data and that it's for contact tracing purposes. You need to store the data carefully. It should not be visible to other customers or to staff who don't need to see it. Okay. I've already heard, I gave an example there a few minutes ago, a theoretical example about my daughter, but I have actually heard about cases of women getting unsolicited phone calls from staff at particular locations in County Wexford, and they're unsolicited, how do I put this nicely, romantic approaches, okay? That can't be happening. It's an absolute breach of GDPR. So we have to limit the data for the purpose for which it was collected. You can't use it for marketing. I've had that myself. You know, you go in, you sign in somewhere to get in for contact tracing purposes, and 2 days later you get a marketing text from that organization, completely illegal. And then you delete the data when it's no longer required, which I think at present they're saying keep it for a month. That certainly was what they were saying some months ago. You shouldn't wander into an office in the building at some point in 6 months' time and find the data from July 2021 still there. It should have been destroyed. Okay, employee resistance to returning to work. Now, this is a question that's getting asked a lot. I'm getting phone calls about this on an almost daily basis. And there's no clear-cut answer, okay? So if you have an employee who's refusing to return to work, what do we need to think about? Well, I should probably have put up there right on top a reference to the work safely protocol, okay? Because the work safely protocol is still saying work from home unless absolutely necessary or where possible. And employees are relying on that and shouting about that from the rooftop. But that's guidance, and guidance only from government. It is not hard law. It's not an incontrovertible certainty, all right? So in terms of looking at it from a hard law perspective, I always start with the contract of employment. If there's a written contract of employment there, what does it say? What does it specify as being the place of work? Or if you don't have a written contract, hopefully you have a statement of terms and conditions of employment which has been given to employees in writing. So there should be some written document if you're complying with the Terms of Employment Information Act that clearly specifies where the workplace is. Standard contracts will often say you'll be required to work at our offices or at our premises at XYZ location, or at such other location as you may be reasonably required to work from time to time. Now, that probably covers working from home during the COVID pandemic. Some employers will have issued revised statements of terms and conditions or updates to statements of terms and conditions. In fact, they should have to advise employees if their workplace has changed. But if a client rings me and says, I want to bring my people back, and so is objecting, that's where I'll start. I'll look at the contract of employment. I'll look at the statement of terms and conditions of employment. What's been agreed between the parties? what's there in the legally binding agreement. And if an employee is saying, I'm not going to return to my workplace at the location specified in my contract, they'd want to have a very good reason for refusing to do so. So a couple of questions then. Have we updated our statements of terms and conditions when people are working from home? If you have a statement of terms and conditions that you've given to your employees that says that they'll work at a particular office and says no more, and they've been working from home for the last year, well, that suggests that the terms of the contract have been amended, and you could now be stuck with them working from home. And secondly, you failed to comply with your statutory obligation to inform them of a change to their work location. So there are potentially problems there. So have a look at what your contracts and statements say and check, have you updated them or amended them as necessary during the course of the year. If you're uncertain about how to proceed, it's a 5-minute call to your solicitor. It's not going to cost you the earth, and any solicitor will be able to give you guidance on that point. There's a possible breach of contract where employees are refusing to return to a workplace. Again, it will depend on the particular circumstances that prevail. So again, it's a 5-minute phone call to get clarity as to where you stand from a legal perspective. But your employees may be breaching their contracts if they refuse to attend at work in order to perform their duties where they're contractually obliged to do so, and you've taken all reasonable measures to protect their health and safety. It can become a disciplinary issue. If you've taken all of those measures, you've got the handheld thermometer guns, you're implementing appropriate cleaning regimes, you've got the hand sanitizer and the tissues on site, you're emptying the bins on a regular basis, you're requiring employees to wear masks, social distancing is being implemented and followed religiously, you've got good ventilation in the workplace, you're doing all of these things to protect them from a health and safety perspective, and they're still refusing to comply with their employment contract in terms of attending at the workplace, and you reasonably require them to attend at the workplace, well, then it may be a disciplinary issue and it may ultimately merit dismissal. It'll be a brave employer who goes there, but I have seen it happening. And it will be happening quite a bit over the coming months as more and more companies, large employers in Dublin, return to the office. We have to take into account the health and safety related circumstances that apply, okay, so that if you're requiring people to return to the workplace and you're not putting hand sanitizer on every available surface, then we might have a problem. You might need to get medical advice or a medical opinion in relation to employees who have disabilities or who are particularly at risk. The Labour Court generally seems to favour employers seeking expert medical advice and following it. So there's a lot of work there for doctors, if they weren't already busy enough, in providing that professional medical advice to employers. Where somebody does have a disability, and that's pretty much any medical condition these days, including things like severe anxiety disorder or anxiety adjustment disorders, almost stress as well. In those circumstances, you're obliged to reasonably accommodate employees. So if your employee is saying, look, I'm on anti-anxiety medication because of all of the issues that have arisen around COVID, including my fear of contracting the disease when I return to work, whether they're being reasonable or not, if they have been medically diagnosed as suffering from that disability, then we need to afford them reasonable accommodation. And generally, the best way of going about that is get proper medical advice and follow it. The issues of cost, in terms of working from home, impact on performance and productivity, etc., I'm going to cover under the next slide, actually, because the next issue that I want to talk about is this so-called right to request remote working. Now, I'm conscious, Emma, that I'm about 3/4 of an hour in. I shouldn't be too much longer, but just shout at me if I go on too long. So in terms of the right to request remote working, One of the impacts of COVID was I wasn't able to engage in some of my normal hobbies. And I took out the 25-year-old set of paints and started daubing on canvas boards badly. And in trying to improve my painting, I started watching YouTube videos. And of course, who comes up? Only Bob Ross. Some of you might be familiar with him, US artist who produced shows in, I think, the 70s. Seems to be big with kids. Anyway, Bob Ross talks about having happy little accidents when you're painting, where you put the wrong color in the wrong place and it comes out looking like a wonderful cloud. So everything's a happy little accident with Bob Ross. Now, the government has had a number of happy little accidents over the last year and a half with COVID. And particularly in the context of remote working. So in response to COVID, they said everybody needs to work from home where possible. And a huge proportion of workers did that. And they noticed that this was having some interesting and unexpected effects. It appeared to be having a positive impact in terms of traffic management. There were fewer people on the roads, fewer traffic jams. We heard mention of the Red Cow Roundabout less often on the morning radio shows. There was presumably an impact then in terms of pollution, and that was noticed around the world. Everybody saw the little videos of dolphins swimming down the canals in Venice. So there's a happy little accident there in terms of pollution. There was a second happy little accident in terms of the housing crisis as far as the government was concerned, because people started to, I'm exaggerating if I say flood out of Dublin, but there was a noticeable movement out of Dublin. We've seen, I think, a 20% rise in house prices in County Wexford, as some of our friends, family, and others have relocated out of Dublin because they're working remotely and can now live down here without having intolerable commute times. And it's had an impact in terms of regional development, and the government can suddenly see a way of addressing a whole range of issues via remote working. And so in January this year, they announced the National Remote Work Strategy, Making Work Remote. And there's a very large policy document that they published at the time, and it talks about taking steps to facilitate ongoing remote working into the future. And they've said that they're going to work towards having 20% of the public sector working from home, to give good example to the private sector. They also talk about three pillars on which they're going to build this remote working strategy over the coming years. The first one is to create a conducive environment for home working by allowing employees to request remote working, by allowing employees this right to disconnect that we'll cover in a moment, and by giving ongoing guidance and improved tax arrangements in the context of remote working. The second pillar is to develop and leverage remote work infrastructure. So they're talking about having remote work hubs. And this brings me back to my days sitting on the board of the County Wexford Chamber, when other members of the board will recall my one significant contribution at every meeting, at least I thought it was my one significant contribution, was to complain about the absence of adequate internet infrastructure in remote parts of County Wexford. And that's still an issue that I'll continue to bang on about, because interestingly, the government's remote work strategy has as its third pillar, building a remote work policy and guidance framework, which includes improving on the national broadband plan, or accelerating the national broadband plan. Funnily enough, I seem to remember the national broadband plan being published 10 years ago, 15 years ago, and telling us that we'd all have fiber broadband in no time. It keeps getting delayed, but now they've an incentive to address it again. So they're talking about having remote work hubs in those parts of the country where broadband is not great. And so rather than commuting to Dublin, we might be commuting to Gorey or New Ross or wherever these remote hubs are going to be. So there's a general strategy or plan to promote remote working over the coming months and years. It's been published by the state. It's on the Department of Enterprise, Trade and Employment and government websites. It's in the pack that I talked about earlier that should be available on our website later today. It's worth having a look at if you're interested in that issue. But there is no right, there's no legal right has been formally introduced as of yet. They're talking about introducing legislation. They mention examples in other countries. Interestingly, Finland, for example, we're told in Finland, under existing legislation, employees can decide, I'm just going to watch now for people having heart attacks on screen here as I say this. In Finland, employees can decide when and where they work for at least half of their working hours. Imagine going into your office or shop or wherever and telling your employees they can decide when and where they're going to work for at least half of their working hours. So that's an example that's being looked at. I think it's more likely that the government will follow the UK example. In the UK, since 2014, they've had a code of practice on flexible working, and that's quite possibly what we'll see here. They have published a consultation document, which was open up until the 7th of May, looking for people around the country to voice their views as to this idea of having a right to request remote working. But I wouldn't get too excited about it just yet, because what they're proposing is that you'll have a right to ask to work remotely, not that you will have a right to work remotely. So what's likely to happen is employers will be required to prove that they have considered reasonably any requests from workers to work remotely. So when people talk about the national right to work remotely, or the right to request remote working, there's nothing there in hard law yet. We do have something in terms of soft law on the right to disconnect. This is the last slide, I promise, Emma. And that right to disconnect, or so-called right to disconnect, was introduced in April 2021 in the form of a code of practice. So a code of practice is produced by the Workplace Relations Commission at the request of government, following consultations with unions and employers' bodies, and it's meant to indicate what the state and the social partners see as best practice. Okay, it doesn't, in fact, create a legal right to disconnect or refuse to engage in work-related activities after normal working hours. But we have seen during the pandemic in particular, new forms of working arising and new patterns of working arising. So it used to be the case that when I came into the office in the morning, there were 2 or 3 emails had come in overnight, and after 6:30 p.m., there will be relatively few emails coming in. Now, probably half my emails come in overnight. There's been a complete change, and the volume of email traffic has increased because people are working after the kids have gone to bed, at night, at home. So somebody sits down to work at 9 o'clock. They can't ring my office number because I'm not in the office anymore most evenings at that time. They're reluctant to ring my mobile number generally. So they send me an email. And when I come in at 9 o'clock the following morning, having had my desk cleared of emails, there's a large volume of emails with complicated legal queries. So work has changed. Now, what does that mean? Well, it means that people are under more pressure. They feel they have to respond outside of normal working hours, and that has given rise to serious concerns. Under the existing Organisation of Working Time Act, you're legally entitled to an 11-hour break between working days. Okay, so you should be able to switch off the phone, switch off the iPad, the desktop, all means of contact, and not deal with work again until the following morning. In some types of work, that is arguably unrealistic, but that's the law as things stand. This new right to disconnect suggests that we have three rights, even though they don't have legal force. A right to not routinely perform work outside of normal working hours. So when you leave at 5:30, that's the end of your day, and you don't have to do anything associated with work until you come into work again the following morning at 9 o'clock if they're your normal working hours. Secondly, it says that you have a right to not be penalized for refusing to work outside of normal hours. I've seen lots of examples over the last year of employers being very irritated by employees failing to respond to emails or calls outside of normal working hours. Employees can now rely on this code of practice in relation to any penalization that occurs. So you didn't promote me because I wasn't answering WhatsApp messages at 8 o'clock at night. That's inappropriate. You didn't, or you threatened disciplinary action against me because I didn't respond to your email that you sent at midnight last night. That's penalization. That's inappropriate. Is there a remedy? There's not an obvious remedy because, like I say, this isn't legislation. It's just a guide, a code of practice. It can be taken into consideration by a court or by the Labour Court or the WRC when hearing a case, but it's not a strictly legally enforceable right. And then the final key thing that the Code of Practice provides for is a duty to respect another person's right to disconnect. So you don't start hounding people when they fail to answer your emails at night. The document does create significant pressure for employers to have a policy on the right to disconnect. So yet another policy document for you to prepare and communicate to staff and train them on. And it contains template wording for that policy. So if you haven't done so already, you should download that policy or that code of practice, cut and paste the wording into a policy, reword it slightly to suit your workplace and communicate it to your employees. And then as long as you respect it, you should be fine. WhatsApp is a nightmare. I've noticed employees complaining the whole time about being contacted by WhatsApp outside of working hours and there being an expectation to respond. Now, with my sincere apologies to Emma in particular, I've exhausted the entire hour and we haven't dealt with any questions yet. But for those who want to stay on the call, I'm more than happy to deal with questions now, insofar as I can, given what I said earlier, that all of this is soft law. There's nothing hard and fast about it yet. Now, Emma, you might help me here. I can't see any questions. They might be there, but...
No, I don't see anything in the chat box.
Well,
it was very informative, Adrian. Maybe there was no need for the questions.
Okay. Well, you're letting me off easily then, everyone. Thank you. And if there are no questions, I'll just wish you the best of luck with reopening. And thank you on behalf of Jacob and Twomey Solicitors and, if I can be so bold, on behalf of County Wexford Chamber for and with any luck, we'll get to see you all in person before too long in a pub.
That's great. Thanks so much, Adrian, for that very informative session on behalf of County Wexford Chamber and our members for your time today. Your answers there, the presentation in itself was certainly greatly appreciated by all in attendance, and I will circulate that document to everybody after the session today. So thank you, everyone. And if there's anything after this call, please don't hesitate to contact any of the Chamber team or myself. for any further supports or any questions you may have. Emer did pop actually a 2-minute business trend survey into the chat box there for anyone has not got to complete that just yet. We would certainly welcome your input. So thanks again, Adrian, for your time today, and we'll chat to you all soon. Thanks, everyone.
Thank you.